Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, America, you may recall the story of Bryan Malinowski. Yes, he was a young man who was gunned down by ATF agents back in Arkansas a little over a year ago, and it had all sorts of kind of odd circumstances and had a lot of us asking a lot of questions, and most of those questions never were really adequately answered. Well, it appears that attorneys for the Malinowski family had a lot of questions, and they came up with a lot more answers than we originally did, and now the lawsuit has dropped. What we're going to do is we're going to actually go through some of the pleadings, summarize it, and give you the actual language in other areas so you can understand what's being alleged here. So today, let's spend a few minutes and let's talk about the big lawsuit that just hit the ATF. Okay, America, you guys are going to recall this case. We talked about it. Everyone else talked about it a little over a year ago when it happened. It was the tragic death of Bryan Malinowski, who was shot at the hands of ATF agents who were serving a search warrant. We'll get to that in a moment. It has now led to the case that we're talking about today, which is Malinowski versus ATF, a lawsuit brought by his surviving spouse and family members. Now, as you recall, we had a lot of questions and a lot of very good questions, and the ATF had a few answers at that time, but not a lot of really good, adequate answers. Obviously, the plaintiff's attorney here has really gone digging, and they are presenting a case that reads as follows. The law does not require us to close our minds to facts which are known to all reasonably intelligent people. If a person is awakened by banging on the door, an immediate and appropriate response may not be feasible. For at least a brief period, the erstwhile sleeper is likely to be too bewildered to react. He or she must then focus on the possibility that those demanding entry may have no legitimate business on the premises. This is especially true when the bedroom is considerable distance from the door, so that a suddenly awakened individual may not hear the officer's oral announcements identifying themselves as police officers armed with a search warrant. Moreover, most citizens are not clad in a manner suitable for opening the door to strangers. If someone is not dressed sufficiently or at all, dressing takes time. Finally, for most people awakened or startled by the loud banging early in the morning, the circumstances are not likely to be conducive to rational analysis or to swift and provident decision making. Now, you will recall that at worst, Mr. Malinowski had been accused of selling firearms without an FFL. Okay, that's it. And you will also recall that the investigation really knew everything there was to know about Mr. Malinowski, and there was at least 100 different ways in which, if in fact they wanted to conduct an arrest of Mr. Malinowski, which was not the focus of this, or a search warrant of the residence, which was the focus of this, it could have been done 101 different ways. However, the method that the ATF chose on the date in question here in March of 2024 led to Mr. Malinowski's death. Now, the plaintiff's attorneys put it this way. The carloads of agents and task force officers had assembled in the dark that morning to execute a search warrant on the Malinowski home. Bryan's suspected crime? Failing to secure a $200 federal firearms license before selling firearms at a local gun show. ATF agents covered up the Malinowski's video doorbell camera with tape, and less than 1 minute later, the team leader ordered agents to pry open the locked glass storm doors and break down the inner wooden doors with a battering ram to breach entry. Less than 20 seconds later, at 6:03 and 46 seconds a.m., gunshots rang out, and Bryan Malinowski crumpled to the ground, shot in the head by an ATF agent following an exchange of gunfire. Okay, now, America, I want you to point out that we have used the term search warrant on multiple occasions. We've highlighted that because at the end of the day, what the ATF was executing here was a search warrant. This was not an arrest for Mr. Malinowski. Now, yes, the product of that search warrant could have produced evidence of a crime, which then could have led to Mr. Malinowski's arrest, but that was not the purpose of the visit. It was to search and secure property, okay? But even if they wanted to just arrest Mr. Malinowski or make sure that Mr. Malinowski was present when a warrant was executed, you have to understand that the ATF literally had figured out every minute of his daily activities. In December 2023, the ATF opened an investigation and began following Bryan to and from work and on the weekends, placing a tracker on his car and surveying his daily activities. During the investigation, at least 2 agents acting undercover interacted with Bryan at a gun show in Arkansas. Bryan answered one of the undercover agents' inquiries by noting that he was a private seller, meaning he believed he did not need an FFL. During their investigation, ATF learned a lot about Bryan. They knew he worked in a secure environment at the airport where guns were not allowed. They knew he had lived a law-abiding life with no criminal history, that he lived at home with his wife and 2 dogs, and that they kept a very regular schedule. Now, again, America, I need you to focus on the type of warrant that was being served here, okay? Again, this was not an arrest warrant. This was a warrant allowing for the search of property. And the plaintiff's attorney makes a big deal here in this way. Importantly, it was not an arrest warrant, nor did it set forth any facts that would lead any person to believe Mr. Malinowski would evade law enforcement, fail to cooperate, be dangerous, or pose a threat or risk of destroying evidence. Now, a lot of people think that this was the Biden ATF's first soiree into enforcing the new engaged in business law. That is actually not true. When this was going on, that rule was being proposed, but was actually not even implemented until a couple of months later. But plaintiff's counsel points out that this was already a big subject of discussion amongst the 2A community. Meanwhile, the change worried law-abiding gun owners nationwide about how the revision could target them as responsible gun owners. The New York Times called the new regulation, which did not go into effect for another month until May 2024, quote, the broadest expansion of federal background checks in decades and, quote, likely to face legal challenges. So I want you to understand that this did not have anything to do with the much stricter engaged in business rule that was implemented for a short period of time. No, this was actually action taken under the old rule. Now, why the violence? Why, when we're just serving a search warrant, did we execute the warrant in such a way that you would have thought that we would be pulling out a fugitive from justice who had already murdered multiple federal agents? Well, as the plaintiff's counsel points out here, they actually didn't follow their true operational plan. Nothing in the operations plan indicated Bryan posed a danger to himself or others, or that he was not expected to comply with law enforcement if he knew they were at his door. The ATF agents, including Agent Bowles, knew that Bryan did not pose a threat to their safety or the safety of others during the anticipated execution of the search warrant. Specifically, ATF investigative officers would learn during their months-long investigation leading up to Bryan's death that Bryan did not pose an immediate threat to their safety or the safety of others during the search, that Bryan had no criminal history or history of violence, that Bryan had never threatened law enforcement officers, and that Bryan's wife and dogs lived with him and he would be present during a pre-dawn search warrant execution at the family home. Now, in the complaint itself, which we're linking up down below, you will learn about the difference between a limited penetration and a dynamic entry. It's obviously law enforcement terminology. And even though the operation plan called for one method, for whatever reason, the ATF chose to implement the other. Now, I know many of you think that, hey, this sounds a lot like Ruby Ridge. It does for many, many reasons. And let us remember that one of the reasons Randy Weaver was acquitted on every single felony was the ATF and the Department of Justice inability or unwillingness to follow their own policies. Now, here's a really weird thing, and this is brought out in the complaint. Apparently, the search warrant was going to be executed approximately a week earlier on March 12th, but the ATF agents called it off. Why? Because Bryan wasn't going to be there. Now, it would seem that if you're there just to rummage through a house and search it and get anything that you possibly can, the safest way to possibly do it would be, well, without the homeowner there. But for whatever reason, they intentionally decided to reschedule it at a time and on a day where they knew that Bryan would be there. Now, the good news is that this was 2024, and with modern technology and all that, everybody had body cameras, so we can just actually see what happened, right? Wrong. None of the agents wore body cameras, despite a 3-year-old policy initiated by the prior administration that mandated ATF's agents wear and activate body-worn cameras when executing search warrants. None of the officers on scene who were equipped with body cameras activated their body-worn cameras either, despite a 2022 policy that called for all TFOs detailed to the ATF to wear body-worn cameras when engaged in federal law enforcement operations. The complaint also states that none of the federal agents wore any clothing that would have clearly marked and therefore allowed the Malinowskis to identify them as federal agents, that they inadequately verbally warned them of the presence of federal agents or that they were with law enforcement. And from the time that they made their first knock on the door until the time they entered, it was less than 30 seconds. And really within a few seconds of entering the home, Mr. Malinowski had been fatally shot. Now, I do recommend that everybody read page 34 and 35 of the complaint, again, linked up down below, because how they treated Mrs. Malinowski after her husband was shot right there in front of her is perhaps almost as appalling as the underlying allegations that bring this complaint to begin with. So on behalf of the Malinowski family, the plaintiff's attorney here brings the following counts in this civil complaint. Count 1, failure to knock and announce in violation of federal law. Count 2, unlawful entry in violation of federal law. Count 3, use of excessive force in violation of federal law. Count 4, illegal detention of Mrs. Malinowski in violation of federal law. Count 5, wrongful death in violation of federal law. And then there are 8 more counts that actually come in under Arkansas law, many state equivalents to what was cited on the federal side. Now, this is a big lawsuit, and what's going to be really, really interesting, and I think that this will be a real bellwether moment for the new and improved Department of Justice and the new and improved ATF, as they claim to be, and right now have clearly shown that they are a significant improvement from the past, is how are you going to deal with this? Is this a case that's going to draw a lot more attention and have a lot more content creators like me or mainstream media or anything like that picking up on this story and talking about what happened? Or is this a lawsuit that's going to be quietly settled? And that remains to be seen. Listen, we're going to go ahead, like I said, and link up the complaint down below so that you guys all can geek out on it for yourself. The case, once again, is Malinowski versus ATF. Now, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.